Welcome to Federal ER Pro, where we focus on the craft of casework. Today, we're going to dive into a critical aspect of federal employment law, crafting effective charges for adverse actions. Part of our The More You Know series. Let's get into it. At the heart of this process is due process notice. This isn't just a legal formality, it's a fundamental right for federal employees facing adverse actions. It's grounded in both statutory requirements and constitutional principles. The core idea is that a notice of proposed action must be detailed enough for the employee to understand the charges and formulate an informed reply. Basically, the proposal must be specific enough, see what I did there, for an employee to be able to defend themselves against the accusations, charges within. It's crucial to remember that notice really encompasses two distinct, yet sometimes overlapping concepts. First, there's due process, which is about clearly stating the charges and the proposed penalty as explained in the previous slide. Second, there's Douglas Factor 9, which addresses whether the employee knew or should have known their conduct was wrong, and to what extent and how that impacts the level of penalty proposed. Both are incredibly important for a defensible action. Think of crafting charges like following a recipe. To uphold an adverse action, you generally need to prove at least one charge. Within each charge, you must prove its elements using evidence, referred to as materials relied upon, or the MRU. Additionally, to substantiate a specification, you need to prove its essence. And proving just one specification can substantiate an entire charge. Every charge has three interconnected components. There's the label, which is the concise title of the misconduct, essentially the indictment. Then you have the elements, which are the specific legal requirements you must prove. The how to prove. Even generic label charges have elements. Although, let's be honest, basically it's that the thing happened and it was not a good thing to happen. Finally, the specification provides the factual narrative, detailing the who, what, when, where, and how. Understanding the elements is your crucial first step in building a defensible charge. You should never initiate a charge without this clarity. It's important to note proving these elements isn't done within the charge's specifications. Instead, they are established through a preponderance of evidence. The relationship between the label and the specification changes depending on the type of label used. With a generic charge like Conduct Unbecoming, the specification truly runs the show and carries the weight. However, with a specific label, the label itself dictates the elements and therefore takes on telling a large part of the story, meaning the specification doesn't have quite as much work to do. Specific labels offer precision. They are concise and well-defined, examples being AWOL, falsification, or failure to follow direction. The benefit here is a clear roadmap for proof, with elements already established by law or precedent. The key rule is that the label controls the specification and dictates the elements, as seen in King vs. Nasalrod. A word of caution, adding modifiers like repeated or willful directly to the label significantly increases your burden of proof. If these modifiers aren't proven, the entire charge can fail. Generic labels such as Conduct Unbecoming or Misconduct are broader and less specific. They offer flexibility, especially when precise specific elements are challenging to prove. The key rule here is that the specification trumps the general label. The entire strength of the charge relies on a clear and comprehensive factual specification. The caution is that without predefined elements, the proof requirements are derived directly from that detailed specification. Not only must you ensure that the specification is detailed enough to overcome the lack of information in a generic charge label, you must be cautious not to write yourself into an intent charge. Then there are narrative charges, which are essentially detailed specifications presented without any formal label at all. While they offer maximum flexibility, they require meticulous drafting to ensure clarity and avoid ambiguity. This approach can lead to due process issues and other complications if not handled carefully. It cannot be stressed enough. The facts dictate the charge. Always investigate thoroughly and gather all the necessary facts before you select your charges. A common pitfall is picking a charge and then trying to find evidence to support it. Avoid this at all costs. Let's look at some examples of poorly written charges. The burden of proof in these cases is the preponderance of the evidence. This means the agency must prove that it is more likely true than not true that the misconduct occurred. This standard applies to every element of every charge, and it also applies to any aggravating penalty factors. Essentially, you need to be a smidgen over 50% sure. Materials relied upon, or MRUs, are the supporting materials, the evidence. Employees have a right to review these materials, and providing them is crucial. A best practice is to provide these MRUs along with the notice of proposal. Now a word on evidence. When drafting charges for adverse actions under federal employment law, keep these guidelines in mind. Only include the offense name in the charge label. All other details, the who, what, when, where, why, and how, belong in the specification. Avoid using characterizations or conclusions in the charge, and reserve adverbs and adjectives for the penalty analysis. Crucially, avoid subjective language like recklessly or egregious in the charge and specification themselves. The words you choose in your specifications also matter greatly. Ensure the language accurately reflects the evidence and avoids overstatement. For example, in Thomas Fort U.S. Postal Service, a specification claiming an employee continually subjected victim to demeaning, sexually derogative comments was not sustained. The evidence showed comments occurred maybe once a week, not continually. Simply removing that word continual could have changed the outcome. Finally, let's talk about intent. Intent reflects an employee's mindset behind an action. Why it occurred, not just what occurred. For charges like insubordination or theft, proving intent is critical. Unless an employee explicitly admits intent, it relies heavily on circumstantial evidence, which an MSPB judge might not find convincing. Proving why is much harder than proving what. Therefore, if evidence of intent is weak, consider opting for non-intent charges, such as failure to follow instructions or unauthorized removal, to avoid risking an unsustainable charge. Thank you for joining this presentation on effectively crafting charges under federal employment law. Feel free to share and subscribe for more insights. Please remember, Federal ER Pro is not affiliated with any federal agency, and this information is for sharing purposes, not legal advice.